person shall be deemed to be Indian origin if he or either of his parents or any of his grandparents was born in undivided India. As your Lordship's my Lord goes through further, your Lordships would find that 6A applies only to people who can fulfill this condition. So for getting advantage or benefit under 6A, I'll have to show that either I was born in undivided India or my father or my grandfather. So your Lordships have three categories. First, the category in which it applies, the Assam, a very limited geographical area. The category from which the persons are permitted, only Bangladesh, a very limited area, and the persons who would be getting the benefit under 6A have to fulfill these conditions, and therefore very less number of people. It may be in thousands.
Now, how did the government, undivided India means undivided India as defined in the Government of India Act of 1935.
That is defined under the
2B. But now under the Government of India Act, undivided India comprised the, Pakistan,
Yes.
Bangladesh also.
Bangladesh was not there.
Of course, it was East
part of Pakistan. Yes.
Today's Bangladesh.
Yes, it was. Yes. Today's Bangladesh was a part of undivided India. But undivided India, Manoj, is defined in the Citizenship Act itself.
It is. It's 2B. I think 2.
It's 2B.
2H.
No, I'm sorry. 2H. To mean undivided India as defined under the Government of India Act 1935.
Yes.
NE. A person shall be deemed to have been detected to be a foreigner on the date on which a tribunal constituted under the Foreigners Tribunal's Order 1964 submits its opinion to the effect that he is a foreigner to the officer or authority concerned. So there would be a judicial adjudication by a quasi-judicial tribunal after giving an opportunity of hearing, meaning thereby due process will be followed, and the person will have to now, this is a case where I want to be declared a foreigner. 6A are not the cases where people would be arguing, I am not a foreigner. People would be arguing, I am a foreigner and therefore I fulfill these conditions and therefore entitled to be a citizen. That's the distinction. This is a separate class by itself, because I get benefit of 6A only if I am declared to be a foreigner falling within the parameters of 6A.
Under the Foreigners Tribunal Order of 64, could an individual go to the tribunal and say that, well, yes, now in view of this 85 amendment, declare me to be a foreigner?
Yes.
Or does a show cause notice have to be issued to him? And
both ways. Both ways. Suppose somebody is, there is an apprehension that he is a foreigner. Then show cause notice would go that you are an illegal immigrant. He will go to the Foreigners Tribunal and say that I fulfill 6A condition and therefore I am a foreigner, but I am entitled to the protection under 6A. If he is not.
Before 1985, nobody would have gone to the Foreigners Tribunal and say, please declare me as a foreigner.
Correct.
Because the consequence would be deportation.
Correct.
So before the 85 Act, there was no question of any individual going.
Correct.
But after the 85 Act, it becomes not a cause for deportation, but it becomes a cause for protection, grant of citizenship.
Your Lordships are right.
So is there a provision by which an individual can go to the tribunal and then say, okay, please declare me to be a foreigner? Or how does it work actually?
I'll show that. But there are provisions under the Foreigners Act. He can go. But that was the root cause of the agitation which started. Because nobody was going for being declared as a foreigner, because the result would be deportation, and therefore the influx created genuine concerns with the ethnic people, and that started, and the government was faced with a situation whether to accept the entire demand of the people of Assam or to permit everyone to come. And I'll show the government somehow brought the issue down to a middle way. What they were saying was that whoever has entered after 51 should be deported. That was, my lord, the demand of Assam Gan Parishad, Assam Students Union, etc. That was the demand when, my lord, the government was negotiating. And therefore, my lord, this 67, 66, my lord, deadline came into being. My lord, I'll show the history.
We would also like to know you may go about it in your own way. How are those dates taken? What is the
Yes, my lord,
logical basis for the dates?
There is
166
I'll
and
just, my lord,
23.
immediately answer that. Lord, I'll immediately answer that. The first date is, my lord, 66. Lord, 66 is taken to be the date because on that date, an electoral roll was prepared containing names of everyone, my lord, whether disputed or undisputed, natives or illegal immigrants, and the elections took place in 67.
Is there any third category other than this? One is of Indian origin. One is other categories of foreigner. Could there be a third category?
My lord, in the context of this matter, there is none. Otherwise, my lord, there is a category of OCI, my lord, overseas citizens of India, my lord. But we are not concerned with that.
In that case, supposing if a show cause notice is issued, to issue a show cause notice, you have authority. That's number one. It should be followed by a final order. There should be some element of adjudication, though not by a tribunal, by the government, government machinery. Supposing he doesn't go, he doesn't choose to go for the tribunal. What is his status? What is to be done for that person?
No, my lord. Then we will have
neither after show cause notice or after the decision arrived at by the instrumentality of the state. If that person continues to be there, or what do you do with the
deportation?
Then what did you do?
Detention and deportation. That's the statutory provision. Unless he proclaims protection under 6A,
no, he would acquire the status of foreigner.
Illegal immigrant.
That is what I am asking you.
Yes, my lord.
Could there be a third category there?
No, my lord. He would be an illegal immigrant.
Then if he is a foreigner, then he will go on before the tribunal.
No, my lord. Illegal immigrant also can go in. My lord, this is how it works. My lord, I can be a foreigner, my lord. If I go to US, I am going with a valid visa.
Therefore, there is another category called illegal immigrant.
That's the only category.
Now, that illegal immigrant will be declared as a foreigner.
Foreigner.
By the tribunal. Correct?
By the tribunal, who deserves to be or who is required to be deported.
That's right. Thereafter, the scheme of the act would come.
Will come.
10 years and other things if he continues there.
Yes.
Now, if supposing he says, yes, I'm a foreigner, there is a need for a determination by the tribunal in that case.
If he says,
you are also saying he's a foreigner, the tribunal will after adjudication holds him as a foreigner, then he will get the benefit.
There are other conditions. For 6A, there are conditions. If my lord, suppose I am coming from Bangladesh and I admit that I am a foreigner.
See, the reason there was a detection.
Answer that question. There would be three contingencies. I'll not say category of individuals.
Correct.
Three contingencies. A person comes with a valid visa. Valid visa would be a time period specific visa, the 6 months. We all go, my lord, with a particular time visa. If person overstays, then he is an illegal immigrant as per the definition. Second, he comes without any travel document or any valid visa, then he would be an illegal immigrant. Third would be normal citizens, my lord, who have come, citizens from Bangladesh who have come but who claim benefit under 6A. For 6A, even if they are illegal immigrants at the time of entry, they have to fulfill certain conditions. So this is the third category. We are concerned only with that third category.
This exactly appears to be their grievance.
That's
Now,
correct.
now, once you decide, once you hold, then after issuing the FOCA notice that you decide the status of person, there has to be a follow-up mechanism on that. Now, that is missing now.
No, my lord, follow-up mechanism under 6A is
Now-
conferment of citizenship.
Now, question is, how many of those persons you deported now? Let us see how many of them are deported now. None, maybe negligible or none. Now, they're neither here nor there, but they are enjoying the status of a citizen now. That is exactly the grievance.
That's not, my lord, with 6A. For 6A, that question doesn't arise.
That is actually the fault of 6A. Because there appears to be a huge gap between an action taken by an instrument of the state and the proceeding before the tribunal. There appears to be, there is a huge gap. Actually, it facilitates. See, one is on the challenge made by them. As we could understand from the argument, is on the effect of it is what they are saying. Now, what the situation as on ground is facilitated by the lacuna under the act. Because neither you push them to the tribunal, nor they are willing to go for the tribunal. This appears to be the case for maximum number of the persons.
No, my lord, possibly your lordships are, my lord,
And they have been allowed to continue.
your lordships have, my lord, in contemplation, post 71, my lord, influx. Post 71
That's a
influx.
different category.
Your lordships are
Even
right.
pre-71, what my learned brother is saying is that there were people who benefited from the grant of citizenship by Section 6A, whether Section 6A2 or 6A3. Now, what happens to those who were not granted the benefit of citizenship, but they are illegal immigrants, and they continue to remain in Indian territory without the grant of citizenship, and nothing was done about them at all?
No, that is post 71 entrance.
Actually, Mr. Solicitor, there are two categories which 6A covers. One, people who came before 1166. Second, people who came between 1166 and 25,371. For those who came before 1166, there were two conditions. One, you must have come from the specified territory, namely that, the specified territory means
Present Bangladesh.
present Bangladesh. Second, you must be of an Indian origin. Indian origin as defined in the provisions of 6A1D, namely both your parents or any of your grandparents must have been born in undivided India. That's the second. And third, that you have continued to be an ordinary resident of Assam since you came before 1966. So 6A2 contained these three provisions, right? 6A3 covers the period 1166 to 25,371. That incorporates all these three conditions, plus a fourth condition, namely the condition of detection. The requirement of detection was not imposed on those who came into India, into Assam prior to 1166. That was imposed for this group of people who came in between 1166 and 25 March 71. So the only difference between subsection 2 and subsection 3 is that subsection 3 imposes one more condition, namely the condition of being detected by the tribe.
So the people who came between 51 and 66 remained without any adjudication.
They remained without adjudication.
That's the section. That's
elaborate further. This second category of person from 66 to 77, what the act actually contemplates is that all of them should be made to go for the tribunal, or machinery should have been developed by the government to make sure all of them shall get
Your lordships are right.
adjudication,
I cannot
It appears to be the objective.
dispute that.
That is
I
missing.
cannot dispute that.
It's missing.
I cannot.
That only triggered everything now.
In that sense, you have a larger group of people. What my brother is trying to point out is, I think,
Other than 6A.
that you have exactly, you have a larger group of people who came from the specified territory. In that larger group, a smaller group of persons who got the benefit of 6A by actually becoming citizens.
Lord, that was a part of the settlement which resulted into, my lord, a legislative enactment. That's the position. But foreigner tribunals are, my lord, functioning. Maybe number of foreigner tribunals are required to be increased. My lord, the space requires to be increased, and for post 71 influx, my lord, the steps need to be taken. My lord, I'm not shying away from.
Though the analogy is not exactly correct in this case, in Ramanohar Lohia, Chief Justice Hidayatullah gave the example of concentric circles. Concentric circles. You know, the bigger circle, the smaller circle.
Yes.
Now, in this case, the bigger circle, to use Justice Hidayatullah, Chief Justice Hidayatullah's analogy, the bigger concentric circle consists of people who came into India from Bangladesh between 66 to 71. The smaller concentric circle within that larger concentric circle is people who get the benefit of citizenship under 6A. The area between the larger and the smaller circle is of people who came in between 66 and 71, but never got the benefit of citizenship.
No, they would get 66 to 71. They would.
Everybody didn't get citizenship.
So they would, Malu.
No, everybody qualified to get citizenship, but everybody didn't get citizenship as a matter of fact. Because unless there was a detection order, you wouldn't get citizenship.
Yeah, correct. Well, no, the detection. Yeah, I understand the point.
Therefore, between that smaller circle and the bigger circle, there was a group of persons who had come, who were still in India, but never got citizenship.
Well, Lord, I'll add one more.
What happened to those people?
No, Lord, I'll just say. Everyone who came between 66 to 71 will have to be given citizenship if declared to be foreigner by the tribunal. The problem is, if the tribunal takes a little longer decision, my lord, for declaration, or either way the tribunal decides whether you are a foreigner or you are not a foreigner, and there is a challenge to the High Court, to this court, remand, etc., my lord, then that period, my lord, they are not getting the citizenship because it has to be dependent upon a final adjudication that you are a foreigner.
Because the difference between subsection 2 and subsection 3 is, under subsection 2, Parliament decided that anybody who came before 1166 would become a citizen, subject to fulfilling 3 conditions: Indian origin, specified territory, and ordinary residence.
Correct.
All right, once you satisfied it, there was a deemed conferment of citizenship. 3 does not do it for those who came in between 66 and 71. 3 says detection by a tribunal is necessary.
Correct.
Now, where there is a detection by the tribunal, those people would be conferred citizenship under 6A3. They get citizenship. What happens with those who never got the benefit? Because then their status...
Never got, my lord, may not be correct.
So tell us broadly.
Okay, can I, my lord, take your lordships the way
the figures,
6A I read?
The figures. How many people got the benefit of 6A2? How many people got the benefit of 6A3? And third, to complete the trajectory, how many people actually came into India between 1950 and 1971 from the specified territory?
Look, some figures are available.
This appears to be the problem. Now, even for those who have come before January 1966, how do you determine? Now, this adjudication by the tribunal declaring them a foreigner, this is again one job of the tribunal. See, now tribunal has got ample power to say this person has come and settled here before 1166. Therefore, then I am confirming that the deeming provision.
No, they don't have that power.
There is no adjudication. My lord, the Chief Justice is right.
So,
there is no adjudication. It's
now,
confirmed by operation.
You have not done that exercise. There must be adjudication on that. Okay, everybody would claim, I have come before 1166. How do you determine this? Now, all of them are immigrants. And different periods, you have given a cutoff period. Now, unless there is a mechanism to deal with this, it creates total confusion. That's exactly what is happening. I would say that come before 1166, then he becomes a citizen.
Actually, conceivably, Mr. Solicitor, there may have been one, because there may have been one, you may be having the files and you may also guide us on that. People who came in between, we are now talking about the conferment of citizenship by an act of 1985, right? This all comes in 1985.
Correct.
Those who came in, say, between 1951 onwards, 51 to 66, the last of those immigrants had come in 19 years before the act was enacted. The first of those immigrants had come in 35 years before the act was enacted. So possibly, at that stage, Parliament felt that those who had come in that far back in terms of antiquity, somebody who came in 1951, to ask that person to prove X, Y, Z was perhaps humanly impossible. Therefore, Parliament possibly made a classification that people who came in before 1966, because 66 is a very watershed, it's a watershed moment. 66 is a watershed moment because the electoral roll is prepared in 66, containing both illegal immigrants as well as our...
Presuming that he was ordinarily residing there.
Therefore, they said after 66, you must demonstrate that, you are detected to be a foreigner. Before 66, Parliament made, really, we must put it at that level. It was a policy.
It was a legislative policy based on the
policy that before 66,
Assam Accord.
In 1985, to tell a person that you show us what were your documents in 1955 would be humanly impossible. 35 years later, who would have any documentation to show that he was in Bangladesh? Many of those people may have died. Their children may have been involved, or those people, their grandchildren may have been involved. So possibly this was a sort of a, we are trying to assess what was the reason for
possibly, my lord, because it's not, my lord,
that's why the distinction between two, because before 66, possibly Parliament thought it's impossible to go into these facts.
Possibly, my lord, the person's name being included in the voters list was taken to be a prima facie evidence that he has been ordinarily residing in India. And, my lord, based upon which Assam Accord, my lord, was made. That all right, 51 to 66, since your names are there, don't give any proof, you will be conferred with citizenship. But 66 onwards, you will have to establish that you came from Bangladesh and you are entitled to the citizenship, for which, my lord, 3 conditions are laid down. And dates are, my lord, taken from the Assam Accord, and the relevance of the date, my lord, I'll just point out. My lord, first is, my lord, the date of 66, 1st of January 66. My lord, the reason is, on that day, the electoral roll for the election of 67 was published. So whoever is there in the electoral roll was possibly presumed to be ordinarily residing and must have come prior to 66. That is number 1. Number 2, my lord, the second date is 25th of March, 71.
That is the date on which 26 is when Bangladesh declares independence.
No, my lord, Bangladesh declared independence on 26th.
That's what I'm saying.
Yeah, yes, but our date is 25th.
Right. That is the eve of the declaration of
independence. No, there is a reason.
What is the reason for that? Tell us.
Yes, yesterday we tried and found out. Lord, on that, there was a communique by the then Honorable Prime Minister of Bangladesh, Sheikh Mujibur Rahman, to the Government of India.
Just 1 second, we'll take it down. To the Government of India?
Yes, Manu. It's communique.
This is 8 February 70. Oh, this is 8 February 72.
72. But there is an undertaking given, my lord, which is mentioned by him, my lord, in this. Lord, please come to the second page of this document.
It's at page 9398 at volume 4A. miscommunication.
What is the page, Mr. Sibal?
398, volume 4A. My
939.
yesterday.
9398.
Volume.
If any of the juniors can
Four.
just check the page and see there.
Yes, I'll just.
Any junior on the both sides can check it for a minute, in case there is some error.
9398.
It's a joint communication based on the end of the.
Yes,
visit of Prime Minister.
correct. This is the one.
So the refugees.
My learned
It
friend is.
appears that the refugees started coming around the 25th of March into India. So this is all history. What happened? What is the trigger for 25th of March?
No, that is mentioned.
Because I saw that the Prime Minister of Bangladesh solemnly affirmed his resolve to ensure by every means the return of all the refugees who had taken shelter in India since 25 March 1971 and to strive by every means to safeguard their safety, human dignity and means of livelihood.
Yes, but
what was the trigger? You just find out. I'm sure you can do a little search in history. What was the trigger in Bangladesh on 25 March 1971? Something would have happened in history.
Lord,
There must have been some incident.
This is not on record, my Lord, but I must assist your Lordships correctly the way I am instructed. Lord, there was a direction by General Yahya Khan that on 25th of March 71, there would be Operation Searchlight. So, meaning thereby, my Lord, an invasion or attack on the Bangladeshis, my Lord. That was the date. That date is confirmed. That date is in public domain. And therefore, possibly the Prime Minister, Honorable Prime Minister, my Lord.
It is Operation Searchlight.
Operation Searchlight. And therefore, the Honorable Prime Minister of Bangladesh said that on 25th, thereafter, we'll take everyone back. It was a solemn assurance given by the sovereign of one country to sovereign of another country.
I'm sorry to interrupt, Malaj, my learned friend permit me. There's the Bangladesh Citizenship Temporary Provisions Order 1972, which is 617 volume 4, which says that it shall come into force on the 26th of March 1971. And in terms of this, all those whose father, grandfather was born in the territories now comprising Bangladesh and who were the permanent residents of such territories on the 25th of March 1971.
That's the sequel of communique. I was coming to that. That's correct. That's because of the sovereign assurance given by one sovereign to another, and that is how, my Lord, the Bangladesh, passed this order. So that is 25th March, but the 25th March is historically, not, my Lord, on record or official stand.
Actually, operations. Right. I was just doing a little Google search right now. It appears that Operation Searchlight by General Yahya Khan was 25th March 1971.
70. Lord, as a matter of fact, my Lord, this was mentioned in the CIA's confidential report, which they declassify after 30 years. And that's available, my Lord, even as a CIA report. Not that CIA's report is to be taken by the courts as a gospel truth. But there also, my Lord, your Lordship would find. That is the, Lord, relevance. Otherwise, it's an odd date. It can be 1st January or something. But 25th March had a significance, had relevance.
Yes.
Lord, now please come to subsection 2. Lord, I am rereading section 6A only to point out that now, of course, my Lord, this would have relevance on the statute book, but it has outlived its utility because nobody would be, my Lord, alive who can, my Lord, take benefit except, my Lord, the progenies. But that is section 3, which your Lordships would be dealing with separately. Please see 2. Subject to the provisions of subsection 6 and 7, but not very relevant subsections, all persons of Indian origin. So, first condition, who came before the first day of entry, so or January 66. So, my entry should be before that.
Yes.
To Assam, meaning thereby the present day Assam, even if somebody comes to Meghalaya, would not get the benefit from the specified territory. So, not from anywhere in Pakistan, only from the Bangladesh part of the Pakistan, including such of those whose names are included in the electoral rolls used for the purpose of general elections to the House of People held in 1967 and who have been ordinarily resident in Assam since dates of their entry into Assam shall be deemed to be citizens of India as from the first day of January 66. Now, my lord, 85 and we are 40 years down the line. So first difficulty is, my lord, we are also not getting much, my lord, factual record, my lord, what was the reason, but appears to be, my lord, logically, that if my name is in the voters list, at least one fact is established that I was an ordinary resident of that area.
Right.
Whether I am originally Indian or I have come from that part of Pakistan which is now under 6A has to be Bangladesh.
Yes.
Then 3. Subject to provisions of subsection 6 and 7, every person of Indian origin, again, my lord, the same definition, who came to Assam. So, my lord, entry will have to be established on or after first day of January 66. So, after the voters list was over, post-voters list period, my lord. But before 25th day of March 71 from specified territory, so not from Pakistan, from Bangladesh, and it is and, not or, and has since the date of his entry into Assam been ordinarily resident in Assam. So, my lord, from the entry till the date of decision. So, not, my lord, few days stay. Continuous stay would be necessary and has been detected to be a foreigner. But to avoid arbitrariness, judicial intervention, findings by a quasi-judicial body, etc., my lord, shall register himself, he is not directly entitled, shall register himself in accordance with the rules made by the central government in this behalf under section 18 with such authority hereinafter in this section, subsection referred to as the registering authority, as may be specified in such rules. And, my lord, now the third, rather, my lord, I'm sorry, fourth embargo, and if his name is included in any electoral roll for any assembly or parliamentary constituency in force on the date of such detection, his name shall be deleted therefrom. So, because he was disenfranchised, those who came after 66, they were permitted to stay without any right to participate in the electoral process. That they got only after 10 years of this decision. Then explanation. In the case of every person seeking registration under this subsection, the opinion of the tribunal constituted under the Foreigners Tribunal's order holding such person to be a foreigner shall be deemed to be sufficient proof of the requirement under clause C of this subsection, and if any question arises as to whether such person complies with any other requirement, please note this, not any other requirement. Any other requirement means A and B, because tribunal would declare only C. The registering authority shall.
A and B, and also whether he is of Indian origin.
Exactly. I'm grateful.
The third, because that is
yes.
before A and B.
Yes. If such opinion, that is tribunal's opinion, if such opinion contains a finding with respect to such other requirement, decide the question in conformity with such finding. Tribunal had the option to give that finding, then it binds the authority. But 2, if such opinion does not contain a finding with respect to such other requirement, refer the question to a tribunal constituted under the said order. My lord, having jurisdiction, my lord, my book also had, my lord, typographical a printing error, my lord, everyone, my lord, we have this problem. This, my lord, of Bare Act, my lord, contains several printing errors. Your lordship's, my lord, Bare Act also must be.
Yes, it's like that.
Having, my lord, this printing error. Order having jurisdiction in accordance with such rules as the central government may make in this behalf under section 18 and decide the question in conformity with the opinion. Then, my lord, registering authority, who is an executive, will not decide. He will refer it to the tribunal that, sir, you have not dealt with this other two conditions. Please deal with it. And, my lord, will act accordingly. A person registered under subsection 3 shall have, as from the date on which he has been detected to be a foreigner and till expiry of a period of 10 years from that date, the same rights and obligations as a citizen of India.
Something very interesting. Even the India Code, I just did a search here right now. India Code, which is the authorized repository of Indian statutes, that also says hang jurisdiction. So it's not the private printers, the private publishers.
We have taken it from this official version.
Professional has a
correct.
He is right, my lord. Universal has, I didn't want to name the publisher, but Universal has this mistake.
The repository in India.
So, my lord, the political solution, my lord, of a problem. Sometimes executive, my lord, is confronted with some problem which needs to be resolved by using legislative means. My lord, there was that, all right, your argument that from 51 onwards, everyone should not get citizenship. You come down to 66, my lord, which they agree. And from 66, the contention was that this large number of influx, and when I show the figures, my lord, the figures, my lord, the time at which the figures are shown, the population of Assam was, say, 1 crore, and the influx was 10 lakhs. So 10% influx, my lord, changes, my lord, right of political participation and right of political decision making, right of jobs. My lord, all of them didn't, after 71 at least, nobody came, my lord, because of any war situation there. Up to 71, it can be understood. Because of economic beneficial position in this part of India, in India, Lord, the land holdings were very wide, very huge land holdings. Lord, the population density was very less. The job opportunities were less. So they came for economic reasons.
They have challenged both subsection 2 and subsection 3, right?
Yes.
They are challenging the entirety.
The
arguments seem to have been more focused on 3 by Mr. Diwan.
Yes, yes.
But the challenge is to the entirety.
They have challenged both. But I'm just not justifying. This was not possibly because what transpired in the meeting between the Prime Minister and the ASU leaders, because I have read the Honorable Prime Minister traveled to Assam and held meetings, my lord. So this appears to be, my lord, a via media which is found out that you don't insist on 51. You come down to 66. Then 66 onwards, we will restrict it up to 71 because 6A says whoever comes after 71 would be an illegal immigrant. No benefit, no nothing. Only foreigners tribunal would decide and you will be deported. But their contention that they are changing the political scenario, political representation, etc. Therefore, my lord, this via media was found that for 10 years, namely till the decision of foreigners tribunal is taken, you will not have a right of participating in the election. And that right came, my lord, only after 10 years of the declaration.
What's the date of the surrender of the Pakistani army actually when Lieutenant General Niazi,
16th December 1971. General Niazi and
Arora on our side.
And Jagjit Singh Arora on our side, my lord. And one Mr. There was a Christian fellow. Peter. Sam Manekshaw. General Jacob, yes, my lord. He was also instrumental.
He was Major General.
Yes. No, Major General was, my lord, Jagjit Singh Arora,
That's fine.
but Mr. Jacob was, I think, my lord, he was, I'm sorry, I stand corrected.
Lieutenant General Jagjit Singh Arora, and if I'm not mistaken, Major General Jacob. Jacob was a Major General.
Jacob, my lord, he was, Jagjit Singh Arora was General Officer in Command of Eastern Command. GOC in command, as they say.
So interestingly, I mean, it may or may not have any bearing on constitutional validity. The cutoff date which is chosen, 25th March 1971, excludes all those who came in during that period of flux in Bangladesh, because the cutoff date is not 16 December 1971, it's 25 March 1971. So anybody who came in, that's right, that's what he just said. But therefore, anybody who came in after Operation Searchlight has been excluded from the benefit of such citizenship.
Yes.
So the Bangladeshi influx which took place as a result of the genocide in Bangladesh, they have been excluded by
because the Prime Minister of Bangladesh said that we will take them back.
They had a cutoff of 25th March 1970.
Because the Honorable Prime Minister of Bangladesh, my lord, said that we'll take everyone who came after 25th March 71 back into our country. Lord, rest of 6 and 7, I'll just orally say, somebody can say that I don't want to get benefit of this. That's all. No, nobody is questioning 6 and 7. And Lord, it is very clear, Lord, from the section that after 71, all are illegal immigrants subject to being so declared by the.
Now we've got the statutory scheme. Now we can go straight to their arguments and address the submission.
Yes, Lord. Lord, if your lordships, my lord, there was a question, my lord, about Rule 19, that which came into force in 2013. My lord, I wanted to answer that question so that I can complete the chronology. My lord, your lordships have seen that 6A will be operated as per the rules framed under Section 18, my lords. Because, my lord, the first impression of everyone was that what happened till 2013. Even the rules are 2009. So there was no vacuum. My lord, that's all I wanted to say. My lord, nothing may possibly turn on that. But just to complete the history, my lord, and the chronology, my lord, Section 6A says that this process will be done as per the rules made under 18EE, small e. That is, my lord, confined to 6A. 18EE, my lord, if your lordships can see. It says 18, but EE, my lord, is, I have found, my lord. It's not entire 18, but 18EE was also, my lord, amended.
And that came in by the same amending act.
But yes. Now, immediately thereafter, citizenship rules were framed in 1956, were amended, I'm sorry. Citizenship rules were already in existence since 1956, but they were amended to bring it in conformity with newly inserted Section 6A. If your lordships would like to have the date, they were amended on 15th of January 1987 to give effect to, my lord, Section 6A. That your lordships would find Volume 4C.
Effect to rule of Section 6A.
Volume 4C, page 3. Page 3. It starts at page 3. I'm not, my lord, none of us, either side, my lord, are required to go through 4C, volume 4C, Roman 4, Roman 3. Please come to internal page 8, or my lord, PDF page 8. PDF page 8. 16 capital D was inserted.
Just a second.
Lord, your Lordships may allow me to read, my Lord, so that it would give, my Lord, some assistance why 2013 amendment was required to be brought in. A reference to tribunals, where in the case of a person, your Lordship, my Lords,
Yes, where are you reading?
Justice Pardiwala.
What are you reading from that volume 4C you're reading?
4C, para A, page 8.
Page 8.
These are the rules of 56, amended in 87 to deal with 6A situation.
15D आया था.
Where in case of a person seeking registration under subsection 3 of section 6A, any Lord, I may not read, but there is a reference provision because nothing turns on that. Then 16E is jurisdiction of the tribunal, which says that it would decide the reference under subsection 3 of section 6A. Last line, my Lord, of page 8.
Yes.
Now, please see 16F. Registering authority for the purpose of section 6A3 and form of application for registration. Now, please come to 2, subrule 2. An application for registration under subsection 3 of section 6A of the Act shall be filed in form 23 by the person with the registering authority for the district in which he is ordinarily resident within 30 days from the date of his detection as a foreigner, where such detection takes place after commencement of the rules, or within 30 days of the appointment of registering authority for the district concerned, where such detection has taken place before the commencement of the rules 1986. Well, there was a time limit prescribed for registration. If I am declared a foreigner and therefore entitled to the benefit of 6A, I'll have to get it registered within 30 days. Lord, the government, from the file, my Lord, it appears, and I have, my Lord, those documents also, that there were concerns that it is not possible to do it within 30 days. So, though we are declared, we have a order of the tribunal, we are unable to get ourselves registered.
So therefore, then they brought in the 2013 amendment to rule 19 and said now 30 days after we issue this notification of these.
That's the reason, my Lord. Just to complete, this is, my Lord, the note of the then Home Secretary giving the justification for amendment in 2013. Nothing, my Lord, may turn on that, my Lord, but just to complete.
See, now we get some data. It is pointed out that on July 2012.
I read.
Right, okay.
It is pointed out that as on July 2012, 32,537 number of persons were declared illegal immigrants pertaining to 6671. So there are other data also in my affidavit. I'll show, my Lord. Streamed by the Foreigners Tribunal. Of this, 12,914 number of persons have registered themselves with the registering authority. The remaining persons could not register with the registering authority due to variety of reasons, including expiration of limit of period of 30 days for registration. As a result, a number of cases have been filed before the Guwahati High Court indicating reasons as to how they could not register with the registering authority and praying that limit of the days for registration be relaxed. It would be difficult to repatriate or deport these category of persons to Bangladesh in view of the understanding between the two countries that persons who came to India up to 24th March 71 would not be repatriated to Bangladesh. Eventually, these persons will become stateless persons if they are not allowed to register with the registering authorities. This is a genuine difficulty being faced not only by the state government but also by the identified persons. In view of the above stated positions, it is proposed that rules may be relaxed as suggested in para 5 of the notes on page 1920. N is notes section. May your lordship knows, my lord. So and so. So, my lord, this is how, my lord, the amendment came. First, my lord, 2009 rules came, and thereafter they were amended in 2013.
One very important circumstance which this note of the Home Secretary indicates is that, as we found from the joint communique which was issued in February 8, 1972, Bangladesh assumed unconditional responsibility to take back those who had come into India after 25th March 1971. Implicitly meaning, therefore, that people who had come into India prior to 25 March 1971, there was no question of deporting these people because Bangladesh would not be willing to take them back. If they were not conferred citizenship, they would be rendered stateless because they would not be going back to Bangladesh. And therefore, it was in that sense a solemn obligation which was undertaken by India in terms of an understanding with Bangladesh that pre-25 March 2071 would remain. And then we must also read it in the context of entry 10 of list 1, which says foreign affairs, all matters which bring the union into relationship with the foreign country.
Correct.
And therefore, the power under Article 72, the executive power would also extend to entry 10. So in that sense, an international understanding between the then Prime Minister of India and the Prime Minister of Bangladesh, that they would take back post 25 March 1971. Now, what would you do? These were not illegal. They couldn't be pushed out of Indian territory as illegal immigrants.
So extend the time and give them more time to get themselves registered.
Therefore, the tacit understanding was that they would remain in India. You couldn't push them out back to Bangladesh because that was not the obligation which was assumed by Bangladesh. Therefore, instead of maintaining them as stateless persons in India, at least bring them into the mainstream by conferring the citizenship on them.
Just, my lord, as a proposition of law doesn't arise here. It doesn't arise here, my lord. Lord,
71, post 1971, there's no question of 6A doesn't.
Even Bangladesh agreeing to take them back, yes, not agreeing to take them back.
They don't have, they don't even
they agree to take them back.
They agree to take them back.
Post 71,
yes.
Post the cutoff.
And they don't even come into the zone of citizenship.
Yes. So they are illegal immigrants.
And therefore, at some point, we'd like to know from the government, what is the government doing in respect of those persons? Because their grievance
in regard to those. My lord, a really serious issue. We have said, my lord, what we are doing, but something more is required to be done. Because there is, my lord, demographic change, and my lord, there are several problems, my lord. Therefore, I started by saying that their concerns, their problems are not, my lord, I am not trivializing. I'm saying they are correct problems. I am only defending 6A, that's all. Just limited period.
The communication, the Honorable Prime Minister of Bangladesh also acknowledges the fact that there are scores of others who entered illegally thereafter.
Lord, whenever they say,
they would be taken back.
No, whenever Bangladesh, the sovereign of Bangladesh says that before 25th March 71, we will take them back, it implicitly gives an assurance that after that, nobody will be permitted to cross over. That's how, my lord, the international relations operate.
Also, Mr. Solicitor, there's one other dimension that Pre-25 March 1971 would comprise of two groups. People who have been granted citizenship, everybody before 66 becomes a citizen, right? After 1166, everybody qualifies for being considered for the grant of citizenship, provided conditions are met. Those who are granted citizenship would become a part of our mainstream. Those who are not granted citizenship, you can't push them out anyway, because Bangladesh is not going to take them back.
Then, my lord, it's not necessary for them. Their agreement is not necessary. If they are not granted citizenship, it would not be possible. That contingency may not arise, because if he is unable to show that he is a foreigner, then, my lord, he is a citizen of India. But if suppose somebody suspects that so and so is a Bangladeshi, I go to the foreigners tribunal and say, no, you are not a foreigner. That means I am a citizen of India. If I am a foreigner before 71, I'll get the protection of 6A. And if I am declared a foreigner after 25th March 71, then I'll have to be, my lord, as per law, pushed back to Bangladesh.
Point.
My lord, please now come to, my lord, some facts and figures. Volume 3, my lord, the affidavit filed by State of Assam, it starts at page 969. My lord, there are several affidavits filed. My apologies. My lord, this is the affidavit dated 5th December 2014, page 969, volume 3. But there are several affidavits filed by both Assam, state of Assam, and the central government. But I'm not troubling your lordships with my lord, other contents, my lord, which are not. 969, affidavit dated 5th December 2014. Six nine six, 969. So the relevant part would be page 982. I'm not going to read anything, my lord. I'm just giving the details which were placed before your lordships. And whatever is relevant for the present purpose and whatever may answer my lord's very pertinent queries, my lord, I'll show. Because affidavits are very long affidavits, etc. My lord. My lord, now please see page 982. Your lordship gets, my lord, page 982. Number of cases, my lord, Chief Justice was. Number of cases before the Foreigners Tribunal and their disposals. The details of cases pertaining to January 166 to March 2471 referred to the Foreigners Tribunal between 86 to 31st July 2014. Because this affidavit is filed in December 14. The figures are as on that date. Total number of inquiries.
Volume 3.
3.
I'm sorry.
Page, PDF page 982.
PDF page, my lord, is 982.
Yes.
There is a chart, my lord, Justice Sundari.
Yes, yes.
There is a hazy chart, my lord. It's a scanning of a Xerox, my lord, possibly. That's why it's hazy.
Yes.
Total number of inquiries initiated for period relating to January 66 to March 71. 52 lakhs. 5 lakh 20,438. Number of inquiries completed 5,22,326. Number of cases referred to the Foreigners Tribunal 42,000. Number of cases disposed of by the tribunals 31,105. Number of persons declared foreigners for period relating to January 166 to March 24, 32,969. Number of persons whose names were sent for deletion from the electoral rolls, the same number. Your Lordship knows they are disenfranchised from the date of the declaration. Total number of persons registered with the registering authorities, 13,914. Total number of persons declared as bona fide Indian citizens for period relating to January 166 to March 24, 71, 27,078. Total number of
got citizenship as of the date of this affidavit is about 27,000.
So, yes.
And 11,000 cases are pending.
11,000 cases are pending. And details of cases pertaining to, the difficulty is
71 and 8.
What about
that is next. That is next. That is, my lord, alarming, and next chart is not covered by 6A. Functioning.
Date on which it was inserted and came into force?
8 December 1985. 7/12/1985.
That is why they have taken it.
7/12/85 minutes.
That is from 86 onwards.
Yes. Now, my lord, the second chart, my lord, is little alarming. Details of cases pertaining to the period from March 25, 71 referred to the IMD tribunal. My lord, there were earlier.
There were tribunals. Some tribunals were there.
Earlier, there was IMD tribunal, my lord, which was set aside in Sonowal judgment, with which your lordships are not concerned, but there was a tribunal. To IMD tribunal and subsequently transferred to foreigners tribunal after scrapping of IMDT Act. Plus, scrapping means it was declared unconstitutional between 83 to July 31, 2014. Total number of inquiries initiated on or after March 25, 71, 7,67,927. Then 2, number of inquiries completed under IMD Act and total 7,44,820. Number of cases referred to IMD tribunal or foreigners tribunal 41,000, 4,19,258. Number of cases disposed of by the IMD tribunal or foreigners tribunal 1,87,294. Number of persons declared foreigners, illegal immigrants on or after March 25, 71, 35,000. Number of persons whose names were sent for deletion from electoral rolls, 35,969. Then total number of persons declared as bona fide Indian citizens on or after March 25, 1971, 64,594. Lord, I'll just clarify this. Lord, they may be falling within 6A, but their decision comes late. Foreigners Tribunal, my lord, took decision late, or there may be a challenge before the High Court, Supreme Court, remand, etc., etc. The total number of cases where alleged persons are not traceable, that is 53,000. Because they enter from Assam and, my lord, spread all over. Mr. Diwan was, my lord, that's why pointing out that they have settled in Delhi. Some of them have, my lord, gone as back as far as, my lord, Jammu and Kashmir, etc. Then total number of persons deported, 2,447. Total number of cases pending before the tribunals, 231,000. This needs to be, now subsequent affidavit says that we have increased the number of tribunals, etc. But something more definitely needs to be done. I will not defend the undefendable. Now, your lordships may, come to the centre's affidavit dated 5th December 14.
This affidavit of Joydeep Shukla is of what date?
5th December 2014.
Earlier one, which you showed us, right? Earlier one, the previous one.
Both are of the same date. 5th December 2014, and centre's affidavit is 5th December 2014.
Where do we get that?
Same volume, 1182, PDF page 1182. I'll just glance, your lordships, take your lordships through, just glancing, just see the heading, that's all. Action plan for detection and deportation of illegal migrants in Assam and effective guarding of India-Bangladesh border. Then detection of illegal migrants, procedure for detection of pre-71. It's substantially the same we have pointed out. Procedure for detection, I'm going fast, so that it's not necessary, therefore. Procedure for detection post-71, there are, what is the procedure put in place? Then deportation of declared illegal migrants, then strengthening of foreign tribunals. That your lordships would find at 1185. My Lord Justice Sundaresh.
Yes.
Then, my Lord, next page, detection of names of declared illegal migrants from the, deletion of names of declared illegal migrants from electoral rolls. Then, my Lord, National Register of Citizenship in Assam. Then effective border guarding for check and control of illegal immigration. It's a porous border. Now, my Lord, fencing is done. There is guarding. There is, my Lord, light shades, my Lord, so that the infiltration still continues, my Lord, which is being sought to be prevented. My Lord, the rest, my Lord, is the steps which we have taken, my Lord, to ensure that there is less infiltration.
This data is of 2014. What is the present situation? How many matters are pending before the foreigners' tribunals?
Lord,
we need that from the state of Assam. The Advocate General can give us up-to-date data. So that will indicate 213,000 cases were pending in 231,000 in 2014. What is the progress? How many have been disposed of? What is the action which we are taking? Because now post 71, 6A constitutional validity is one aspect.
Yes, yes.
But Mr. Solicitor, as you also say, what Mr. Diwan has argued, what Mr. K.N. Chaudhary has argued, and Mr. Ansaria, you are also not denying the gravity of the problem as it exists.
It is a serious problem.
So we want to know from the government of India, what are we doing now? Because this is not just about changing the demographics of Assam. That's one aspect, the cultural aspect which Mr. Diwan highlighted, but also the burden on the existing resources.
Sources, my Lord, and those who should go to Indian citizens are, my Lord, now being unauthorizedly shared by someone who comes only to share the resources.
People go from here to Mumbai.
Works because the affidavit says it is to be complete.
That also, my Lord, as latest fencing work till date. There is one affidavit of 2018, my Lord, but latest.
People got citizenship in the pre-1166 category. How many people have got citizenship, say, with the cutoff date as 1166? How many people have got citizenship 1166-25-371? And the third period is post 25-371.
When question of citizenship doesn't.
That doesn't arise at all. Because post 25-371, government has to be extremely serious about what is happening on the ground.
Yes.
They may succeed on their constitutional challenge, they may not succeed, but
This
what they are saying has a great deal of substance, not only in relation to Assam, but for the rest of the country as well.
Because, Lord, they are not coming here because they are persecuted or there is some problem.
Yes.
Second. 6 to 7. $1193.
Of how many people have entered post 25 March 1971? Approximately. Because do we have any estimate of that in India? Two, how many matters are pending as we post to the Advocate General? How many matters are pending before the tribunal? How many tribunals do we have? Because frankly, we will deal with the issue of constitutional validity, which is something which we have to consider. I mean, that's a very weighty argument. But assuming everything that we affirm the validity of 6A, what are we doing post 1971?
As a matter of fact,
one other aspect which you may consider. See, our point also is that the very problems which the Solicitor General is projecting also happen in the context of Bengal, West Bengal.
We are going to come that. We come to that. Also, when you're answering now, I think we've understood the broad lay of the matter. What we'd now like to know from you is the Article 14 argument, the cultural impact, etc. We'll hear you very briefly. But your point really will be that, look, this was basically political policy. And therefore, this is something which is factored in. But we'd like to hear you on that. But most important, why did you single out Assam when we found yesterday that West Bengal shares a much larger border with Bangladesh? And therefore, presumably, the extent of illegal migration into West Bengal would be as or even more significant. Or did we have any cogent data to indicate that the extent of illegal migration into West Bengal was minimal as compared to this? Therefore, we left it alone.
No, my lord, we don't have. And this is the answer which I am going to give, my lord.
Now, what my lord is saying is that now, after Assam, this illegal immigrant will get into more and more they get into West Bengal now.
Absolutely.
What is going to see? Therefore, we want to know how do you propose to deal with this? At least after 71,
And Mr. Solicitor, there are a couple of, we have to look at it at different layers. First, there is a layer of legality, that we deal with these illegal immigrants who are here with due process of law, because we are not some authoritarian country that you just pick them up and treat them, and show the power.
The process is the tribunal.
We have to follow process of law because we are a democratic country governed by the rule of law.
Correct.
And there's a grave danger that you might actually pick up. If you don't follow the rule of law, genuine people may be picked up and thrown out. That's something we must also.
Yes.
But more important than also, What are we doing from here
onwards.
for the future? What is the government of India doing in terms of ensuring that you have an impermeable border? How much investment is the government of India taking into ensuring that the border becomes, in that sense, impermeable?
Lord, I understand.
What are the executive steps which the government of India is taking? Have we, to what extent has the border been fenced? We understand that parts of the terrain is impossible to be fenced also, but what are the steps we want to know? Because this is a crucial problem, independent of 6A.
1126, my lord, may give some answer, my lord. Lord, this is again as of 2014. This is regarding border fencing, my lord, Justice Suryakant's query, my lord. My lord, apropos, my lord, yes, my lord, that is given, my lord, in the affidavit. Yes, my lord. What is the process? What is the procedure followed? That is undertaken, my lord. That is undertaken. They are being subjected to the Foreigners Tribunal jurisdiction. Data, my lord, we will provide.
As Government of India, does Government of India have data? And Mr. Solicitor, we understand the problems of all this as well, because culturally, you're dealing with people who look exactly like you, they speak the same language, they dress the same way.
No.
What is the data with the government? What is the extent of the illegal immigration post 71?
My lord, I'll just, my lord, point out.
Do we have that data?
No, this is my answer, my lord, not the government's answer, my lord, because I could not, my lord, get it from the record. So far as Bengal is concerned, my lord, the general discussion which I have with the officials is that Assam faced the problem and raised it at a level for the simple reason that culturally, Bangladeshis and Assamese were so different that it was easy to identify. In case of Bangladesh, their language, their food habits, their dressing, everything, they mingle very easily, number one. Number two, because of that, maybe there is no uproar or something, but that does not justify the government not taking steps. I must admit.
Correct. With great respect to my learned friend, regarding dresses, there are a lot of differences. One can make out.
Between?
Well, not predominantly Assam is a.
No, he is agreeing with you. He's saying
I'm supporting
Bengal. He's talking about Bengal, not Assam.
I'm talking about Bengal.
Bengal. That's why I thought I'll clarify. I got your point. We realized what was in your mind. He was talking about Bengal. But now tell us, what have we...
What I'll do is...
Look, one way, Mr. Solicitor, their argument is, strike it down under 14, you didn't do to West Bengal what you have done to Assam. You have an equal illegal immigration into West Bengal, you've just let it be. Let it be in the sense they are liable to be deported. You granting them legality in Assam. One is the 14 argument. But beyond that now, we are going beyond the validity argument.
Correct.
What are we doing? Why? First, we want to know, what was the reason which prompted Parliament to exclude West Bengal from the grant of citizenship? We are not saying that they should have granted it. But why? What is it that led us to believe that this problem was peculiar to Assam and not to... Argument could not have been from the Indian perspective that there was an agitation in Assam.
Cannot.
The argument from the Indian perspective is we have to do what is good for the nation.
Yes,
right? Why did we leave West Bengal alone? Second, what is the extent of illegal migration between 1971 onwards, and what is the position as West Bengal? And what is the government doing in West Bengal now?
I must admit, Lord, right now, my Lord, my preparation was on the validity part and legal part, but matter may not end today.
So we'd like
Undertake to file an affidavit of the authorized officer, Lord, latest by tomorrow or day after, on all questions, because
and we would like an updated statement from Government of India. Let the Home Secretary also apply his mind to this.
yes.
What is the Government of India doing in terms of safeguarding the border, in terms of border fencing? What is the updated position? How far has the border fencing arisen? Because this is also crucial in the sense of, we get all these matters which come up before us every day about, the...
Foreigners Tribunals Award.
No, about the people seeking bail because they've been, when they've been caught, cattle smuggling, so-called cattle smuggling, involvement with we've also had cases, you will recall, of our own paramilitary forces, officers being involved with that.
Yes.
Those people have been proceeded against.
Yes, sir.
So all this is a very serious
Well,
problem.
my Lord, I undertake that Home Secretary will file an affidavit.
Bengal a party to these proceedings?
I think all states
All
are part.
states are right. You are a,
My lord, state of Tripura also has equally the same problem.
but
In fact, Tripura, it is
one second, we will come to Tripura in a moment. Who's appearing for the state of West Bengal?
State is a party.
Have they filed an affidavit?
But
Have they
all
filed-
states are parties.
Mr. Diwan,
One of
Mr.
them.
Chaudhary, has West Bengal filed an affidavit in this proceeding?
Just check.
That is going to be a problem.
State is a party, my Lord. But I will, my Lord, I assure your Lordships, the Home Secretary will file an affidavit on all these concerns.
We would like to
Reason
have
is
an
this.
affidavit from them also.
The
From the state of West Bengal also, their official stand we want to know.
Certainly, my Lord. The reason is this, my Lord. Forget, my Lord, anything else. Your Lordships are a constitutional court, my Lord, protecting fundamental rights of every citizen. Lord, this would be a part of fundamental rights of large section of citizens, my Lord, in large, my Lord, in several states where, my Lord, their natural resources, their other resources, my Lord, are being shared only on economic grounds.
Now, Mr. Solicitor, let's go rapid fire now on your argument to
Yes.
your response to constitutional validity.
Yes. Kindly, my
You've
Lord.
shown us the statutory scheme, right?
Yes.
Just tell us now what is your answer to the constitutional challenge.
Yes, my Lord, please come to, my Lord, my written submissions, volume 2A.
Volume 2A.
2A, my Lords. And I'll, my Lord, as your Lordships have said, rapid fire, I'll skip, my Lord, what is, they may be treated as read, my Lord, but volume 2. Lord, to page 8. I'm skipping, my Lord, whatever is not relevant immediately. Lord, enactment of section 6A, the history, the background behind it, my Lord. There was a debate in Parliament. Your Lordships may not get much on that, my Lord, except that I'll just, my Lord, paraphrase so that your Lordships may not have to read. Assam Accord provided and the government has agreed, that is one. Number two, at the relevant point of time, the war. And therefore, people have come. And most important, my Lord, your Lordships would get at page 10, because there was an argument of Article 11, my Lord, that this amendment is virtually amending Article 4 and 5. My Lord, that was 4, 5 and 6, I'm sorry, 5 and 6. My Lord, that was, my Lord, dealt with. when 6A was being framed by the then Home Minister, my lord. Please see, my lord, page 9, Shri S.B. Chavan, the then Home Minister. Page 10, my lord. Page 10. Your Lordship gets, my Lord Justice. I am also referring to Article 11 of the Constitution, which clearly lays down that government is within its own powers to enact legislation conferring or terminating the citizenship, any of the rights which a citizen can possibly have. So this is a very wide power which has been provided for. There is no question of any infirmity under the Constitution or any other law for the time being in force. My Lord, then your Lordships can skip the rest and come to, my Lord, page
Just
11.
that little part PDF to that part in the middle. We have made a commitment.
Yes, my Lord, that's what I said.
That is a little important because
We have made a commitment to stop a large number of infiltrators who have been crossing over. The average rate comes to about 2,400 per month. All these people have been trying to cross, and we have been trying to push them across the border. There is no denying the fact that the people have come. Whatever Bangladesh government might say, I can say without any fear of contradiction that in fact, a large number of people have come. But they had come in a very peculiar circumstances, and that is why we could not possibly afford to take very harsh attitude, and that is why conciliatory attitude had to be taken, and that is why legislation is there. Lord, he says about post pre-71, but admitting the position that this position has continued even after 71.
What was the statement of objects and reasons of the bill introducing Section 6A? What did the statement of objects and reasons say?
My Lord, to give effect to the Assam Accord. I tried,
That's all.
but my Lord, your Lordship
Nothing
did not
beyond
get any
that.
assistance from that. My Lord. Therefore, my Lord, we tried and searched the debates of Parliament. Then, my Lord, at the foot of page 10, the bold part, Sri Bhadra Pratap Singh, this unprecedented situation was not contemplated by 1955 Act. Therefore, this present amendment is trying to solve that situation, and Parliament is competent under Article 11 to enact this kind of a legislation. Then, my Lord, Mr. P.A. Sangma's, my Lord, is relevant at page 11. He was, my Lord, MOS in Department of States. Members from this side and the other side, including, I think, Mr. Babul Reddy himself, have pointed out that Parliament is competent to decide on all matters relating to citizenship. And this has been very clearly, very expressly, unambiguously put forward in Article 11 of the Constitution. Therefore, the constitutionality of this bill cannot be doubted. The power of Parliament to enact such a bill cannot be challenged at all. My Lord, on 11, let me, my Lord, complete my submissions in 5 minutes. My Lord, A. And my Lord, there is a interesting Constituent Assembly debates when 11 was being framed. Yes. They say that we have to leave it to the Parliament. How? My Lord, Article 4, Article 5
formulated A, B,
it is there, it is there. But my Lord, I'll just orally point out and then, my Lord, show your Lordships. Lord, Article 5 and 6 talks of deemed citizenship. That if you are born or if you have come before a particular date, Article 6 and 7.
6 and 7.
6 and 7, I stand corrected. Then you are deemed to be a citizen of India.
Yes.
That was when the Constitution was framed. Subsequent to the Constitution, there may be situations where the nation needs to confer citizenship on various other grounds or take away somebody's citizenship on certain grounds, and therefore Article 11.
Acquisition and termination.
Yes. So 6 and 7 are deemed citizenship when Constitution came. 11 is for future contingencies. Second, and my lord, this is on textual reading only. If 6 and 7 were to be frozen in time, as argued by the petitioner, then why have 11 at all? Then 6 and 7 is complete code. There cannot be any additional reasons for conferment of citizenship, or there is no provision for taking away citizenship.
To which their answer would be that Article 6 and 7 is Pakistan specific. That it basically deals only with Pakistan, right?
Correct, my lord.
So the purpose of 11 is broader. 11 covers, but it will, Article 11 would not cover only Pakistan. It will cover the entirety of the
Entirety of the world. Well, there may be several citizens, for example, my lord.
The argument was that once, which you have to deal with, which is that once the date of 19 July 1948 is chosen in Article 6 for the conferment of deemed citizenship, then the argument was that you can't, by the exercise of an ordinary legislative power, reach that date of 19th of July 1948 because Bangladesh, 25 March 1971 and prior thereto, Bangladesh is a part of Pakistan. The area of Bangladesh now, specified territory is a part of Pakistan. Albeit is Pakistan. Now, therefore, the argument is that you can't, in respect of a period covered when the specified territory was in fact a part of Pakistan, can't confer by deeming citizenship, by deeming an act of citizenship, because 6A also is deeming
confer
citizenship.
but not deemed.
You can't, yes, you can't, because you are making a deeming fiction. And that deeming fiction can't transgress the limitation which has been prescribed in Article 6. That's the argument.
The answer your lordships would get from the Constituent Assembly debates, which I have quoted, relevant part of only Article 11. Because well, the theme is they want to say to us, why should they?
To that, one answer to that which we put to them was that Article 6 deals with the position as of the date of the adoption of the Constitution.
That's
it
what
basically dealt with the historical context of partition. Article 6, the answer probably would be that Article 6 does not tie down the hands of a future parliament to decide to
the contingency is not contemplated
in Article 6. Article 6 can't be regarded as an exhaustive universe. That would be the simple answer, I think.
So your lordships would see Article 6. They say at the commencement of the Constitution. So, and they say very categorically while drafting the Constitution, while Article 11, that we may not be able to conceive of situations which might arise in future.
It's a declaration of citizenship for a group of people under the Constitution. That's
at
all.
That point of
that's time, over. That's
under
over.
those circumstances.
To accept their argument would mean that Article 11, the ambit would be to all countries other than Pakistan.
Yes.
Because that would be perhaps a very narrow reading of the power which is conferred by Parliament.
Another thing, apart from the fact that Article 11 starts with nothing in the foregoing provisions.
It's a non-obstante clause.
Initially, when it was introduced as a draft, it said further provision governing citizenship, which was deleted consciously. Just give me 5-10 minutes. Can I please come
Where
to
is that?
page 12, 14 of my written submission. 13 starts with drafting history of part 2, entire part 2, but we are more concerned with article 11. Para 37. Does your lordships get it? 37. On 29th April 47, while moving clause 3, Sardar Patel requested that the following should be added to clause 3, thereby empowering the union. Further provision governing union citizenship may be made by laws of the nation. This was, my lord, the beginning of Article 11. This was conceived by Sardar Patel, my lords. My lord, thereafter, your lordships may, my lord, directly come to, it was referred to a committee. Please come to para 44. And the redrafted clause by the committee is, my lord, at para 44. It went before 3 different committees, my lord, this Article 11 issue. Thereafter, Sri B.N. Rao.
The constitution of the committee, it had Vardacharya.
My lord, all were eminent. My lord, please see.
Mittar, Alladi Krishna.
Kanayalal Munshi, K.N.
Kaju, Munshi
and Dr. Ambedkar himself. We were fortunate to have, my lord, this constitution because of, my lord, people of this eminence and intellect. Then, my lord, what they suggested was every person born in India, in the union and subject to its jurisdiction, every person either of whose parents was at the time of such person's birth a citizen of union, and every person naturalized in the union shall be a citizen of union. Further provision regarding the acquisition and termination of union citizenship may be made by the law of the nation. Still further word remained, my lord. Thereafter, my lord, it was redrafted, and your lordships would find at page 44, para 3 only, my lord. Further provisions governing the acquisition and termination of union citizenship may be made by union law, that is parliamentary law. Then 45. Meanwhile, the Union and Provincial Constitution Committee at their joint sitting on June 5 appointed a subcommittee to consider in detail the effect of June 3 plan. My lord, that is Mountbatten plan. My lord, it's referred to as June 3 plan. The joint subcommittee met on June 8 and decided that the question of nationality and citizenship in the union should be re-examined by the ad hoc committee in light of the plan. In the report submitted by the Assembly on July 4, the Union Constitution Committee incorporated the citizenship provisions contained in the memorandum without any change, except that the word union was replaced by the word federation. My lord, your lordships can skip that. And, my lord, please see the committees, my lord, is quoted, my lord. In this connection, my lord, page 16 top. In this connection, the committee quoted with approval the view of Calcutta Law Journal. It is not possible to define exhaustively the conditions of nationality, whether by birth or naturalization, by the Constitution. If certain conditions are laid down by the Constitution, difficulties may arise regarding the interpretation of future legislation which may appear to be contrary to or to depart in any way from them. The exact argument which is made. It would, in our opinion, therefore, be better to specify who would be citizens of Indian Union at the date when the Constitution comes into force, as in the Constitution of the Irish Free State, and leave the law regarding nationality to be provided for by the legislation by the Indian Union in accordance with accepted principles of private international law. But this gave birth to Article 11. It is now in the evolution process, my lord. My lord, please see para 48. When the draft was presented, but I will not read, there were 140 amendments to the Constitution. Dr. Rajendra Prasad was pleased to say that you have it as a composite thing. Don't go one by one, but not relevant. Please come to para 50. Am I with your lordship?
Yes, sir.
Para 50. The Constituent Assembly debates with regard to citizenship and especially Article 11. Lord, it was draft Article 6. So somewhere there would be a reference of Article 6, but that is present 11. Is illustrative and clearly points towards an overarching power being available to the Parliament. The following are the debates. Dr. Ambedkar, Mr. President, sir, except one other article in the draft constitution, I do not think that any other article has given the drafting committee such a headache as this particular article. I do not know how many drafts were prepared and how many were destroyed as being inadequate to cover all the cases which it was thought necessary and desirable to cover. It is not the object of this particular article to lay down a permanent law of citizenship for this country. So it is very categorical. The business of laying down a permanent law of citizenship has been left to Parliament, and as members will see from the wording of Article 6, which is present earlier, my lord, avatar of 11, as I have moved, the entire matter regarding citizenship has been left to Parliament to determine by law that it may deem fit. The effect of Article 6 is this, that Parliament may not only take away citizenship from those who are declared to be citizens on the date of commencement of this constitution by the provisions of Article 5 and those that follow, but Parliament may make altogether a new law embodying new principles. They must not understand that the provisions that we are making for citizenship on the date of commencement of this constitution are going to be permanent or unalterable. All that we are doing is to decide ad hoc for the time. I don't think, with respect, there can be anything more clear than this. Then, my lord, next Dr. Rajendra Prasad, my lord, only highlighted part I may read. I would therefore suggest that amendments of this nature might also be left over to be dealt with by Parliament at a later stage, and we might confine ourselves to the limited question of laying down the qualification of citizenship on the day of Constitution came into force. As my lord, the Chief Justice, my lord, said. Then, my lords, your lordships may kindly come to page 19. There are other, my lord, honorable members saying the same thing, but page 19 is Lord Dr. Alladi Krishnan, Sri Alladi Krishna Swami Iyer, my lord, at page 19, my lords.
Yes.
Sri Alladi Krishna Swami Iyer. The articles dealing with citizenship are therefore subject to any future nationality or citizenship law that may be passed by Parliament. Parliament has absolutely a free hand in enacting any law as to nationality or citizenship suited to the conditions of our country. It is not to be imagined that in a constitution dealing with several subjects, it is possible to deal with all the complicated problems that arise out of citizenship. Then, my lord, Hridaynath Kunzuru also, my lord, only highlighted part. There is nothing permanent about the qualifications laid down in Article 5 to 5C. I'm sorry.
Yes.
5 to 5C. Article 6, that is 11 present, my lord. Slight modification that further becomes, my lord, nothing contained. Article 6 makes it absolutely clear that notwithstanding the provisions of these articles, Parliament will have power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Any defects that experience may disclose can therefore be easily rectified. The Parliament get experience, they need more qualifications, they need to take away citizenships, not concerned in this case, but generally.
Yes.
Sorry, I did something, yes. Lord, now, my lord, your lordships have, my lord, on the last day when my learned friend was distinguishing the judgment which I was to cite, have seen, my lord, at page 21, on interpretation of Article 11. That is, my lord, Izar Ahmed Khan versus Union of India. My lord, this is the judgment by 5 honorable judges, my lord. I'll read the highlighted part. It's, my lord, authored by my Lord Justice Gajendra Katkar. At page 21, bottom highlighted part. Article 11 confers and recognizes the power of Parliament to make any provision with respect to not only acquisition but also termination of citizenship, as well as all matters relating to citizenship. Thus, it would be open to the Parliament to affect the rights of citizenship, and provisions made by the parliamentary statute in that behalf cannot be impeached on the ground that they are inconsistent with provisions contained in Article 5 to 10 of Part 11, Part 2. So clear that 11 is an independent power and it can add to.
Let's read the next sentence also. In this connection.
Yes, I'll just, my apologies. In this connection, 246, it is important to bear in mind that Article 11 has been included in Part 2 in order to make it clear that the sovereign right of Parliament to deal with citizenship and all questions connected with it is not impaired by the rest of the provisions of the state part. Therefore, the sovereign legislative competence of the Parliament to deal with the topic of citizenship, which is part of entry 17 list 1 of the 7th schedule, is very wide and not fettered by the provisions of Article 5 to 10 of Part 2 of the Constitution. This aspect of the matter may have relevance in dealing with the contention raised by the petitioners that their right under Article 19 are affected by the impugned provisions, etc. So, my lord, this is the only judgment, my lord, on Article 11, but even textually and keeping in mind the drafting history, the only inevitable conclusion is that they say we cannot conceive of many future situations, we leave it to Parliament. So, my lord, this distinction between deeming or conferring, Lord, may pale into insignificance. My lord, page 24, your lordships may not read. I have just given, my lord, the words which are used in the Article 11, which starts with nothing in the foregoing provisions, my lord, are used only in these articles. So it is, my lord, elevated to that level. That's all, my lord. Nothing beyond, my lord, turns upon that. Lord, Article 324, my lord, my learned friends have not also, Lord, seriously pressed, my lord, so I'll not trouble your lordships with that. Please directly come to page 29, my lords. He also did that. Lord, Sarvanand Sonowal judgment, I have just said, my lord. Sarvanand Sonowal judgment was concerned with one act.
MDTR.
And the argument was that look at the serious situation on ground. This act does not fulfill the object it seeks to achieve. And on that ground, Sarvanand Sonowal was, Lord, declared, was pronounced, and that act was declared unconstitutional. It, in fact, supports that this is a huge problem. But your lordships are not, my lord, right now concerned with right, Lord, correctness or otherwise of this judgment. Then, my lord, scope of judicial review in relation to treatment of foreigners, my lord, I may not trouble your lordships with. My lord, please treat this as read, my lord, because your lordships are aware of the settled propositions of law on this. Please come to page, Lord, 34. Lord, challenge concerning Article 14. Here I'll read, my lord, only one or two judgments, my lord. At page 35, this is a judgment by 7 honorable judges. Special Court Bill. Only 71. There are numerous cases which deal with different facets of problems arising under Article 14 and which set out principles applicable to questions which commonly arise under that article. Among those may be mentioned the decisions of so-and-so, so-and-so. Then, my lord, highlighted part. But as observed by Justice Matthew, in the last mentioned case, it would be an idle parade of familiar learning to review the multitudinous cases in which the constitutional assurance of equality before the law has been applied. But, my lord, thereafter, my lord, at page 36, the Honorable Court, 7-judge bench, my lord, earmarks what are the contours your lordships would consider while examining a challenge under Article 14. And relevant, my lord, all are relevant, of course, my lord, but please come to 5, just, my lord, at the foot. On the classification, my lord, my learned friend's argument was there is a classification. Well, I'm dealing with that submission, my lord. By the process of, your lordship gets that, my lord. By the process of classification, the state has the power of determining who should be regarded as a class for the purposes of legislation and in relation to a law enacted on a particular subject. This power, no doubt, in some degree is likely to produce some inequality, but if a law deals with the liberties of a number of well-defined classes, it is not open to the charge of denial of equal protection on the ground that it has no application to other persons. Classification thus means segregation in classes which have a systematic relation usually found in common properties and characteristics. It postulates a rational basis and does not mean herding together of certain persons and classes arbitrarily. The law can make and set apart the classes according to the needs and exigencies of the society and as suggested by experience. It can recognize even degree of evil, but the classification should never be arbitrary, artificial, or evasive. The classification must not be arbitrary, must be rational, etc., etc. My lord, your lordships are well aware of the propositions, my lord. So I'll not, my lord, trouble your lordships with that. Please, my lord, come to the case of, my lord, Ajayab Singh, which is at page 38 at the foot, my lord, para 111. That, my lord, lays down substantially the same test. My lord, I may even, my lord, skip that. So please come to page 40. My lord, under classification, my lord, I'm duty bound to answer on facts on the question of Bengal. But my legal proposition, my lord, is this. And I will do that, my lord, in the within a day or two, by way of an affidavit filed by the Home Secretary. But the argument is, instead of 1, you should have done it for 5. So argument is of under classification. That may require law to be made for others, but would not be a ground to declare the law already made ultra vires. First judgment is N. Venugopala Ravi Verma Raja versus Union of India. And please at page 41 see, my lord, the highlighted part. Under classification is always not a, my lord, ground of a successful challenge on Article 14. But the mere fact that the law could have been extended to another class of persons who have certain characteristics similar to a section of Hindus but have not been so included is not a ground for striking down the law. In treating a Hindu undivided family as a unit of taxation under the Expenditure Tax Act and not a non-Hindu undivided family, the Parliament has not attempted an obvious inequality. Then, my lord, Ajay Kumar Banerjee, only highlighted part, we may reiterate that Article 14 does not prevent legislature from introducing a reform, that is, by applying the legislation to some institutions or objects or areas only in according to exigency of the situation, and further classification of selection can be sustained on historical reasons or reasons of administrative exigency or piecemeal method of introducing reforms. Maybe for other states, law may come, but that would not make 6A ultra vires. So special provision for one state, historically because of Assam Accord, etc.
Yes.
Yes. But kindly, Ambika Mills, my lord, is a settlement. I'll not read that, my lord. Then territorial classification, your lordships would get, my lord, 43, page 43. Territorial classification is justifiable. Well, this is my submission in law. But factually, since it has fallen from the court, my lord, and the court, which is a constitutional court, taking care of fundamental rights of everyone present here or otherwise. Lord, I must answer the question regarding, my lord, territorial classification. Why not Bengal? Why only one state? Why not Tripura, etc. Lord, ODUL, my lord, your lordships are aware, my lord, I'll just read the highlighted part. Historical considerations and compulsions do justify inequality and special treatment. Then, my lord, next page, next para, highlighted part. And if after reorganization of states and integration of the PEPSU Union in the state of Punjab, different laws apply to different parts of the state, that is due to historical reasons, and that has always been recognized as a proper basis of classification under Article 14. Then, my lord, state of MP versus Bhopal sugar mills. Your lordships will come to next page directly, my lord, at page 44. The legislature, my lord, I'm reading the highlighted part. The legislature has always the power to make special laws to attain particular objects, and for that purpose has authority to select or classify persons, objects, or transactions upon which the law is intended to operate. Differential treatment becomes unlawful only when it is arbitrary or not supported that by a rational relation with the object of the statute. This court has held in several cases that where application of unequal laws is reasonably justified for historical reasons, a geographical classification founded on those historical reasons would be upheld. Lord, the same thing is, my lord, Lord, rest as settled propositions. If your lordship permits, I may skip, my lord, because just, my lord, your lordships gets our side of, my lord, judgments on one in one submission, my lord. I have yes, my lord. One last point, my lord, page 49. On classification where the law is made only for Assam. I'll just, my lord, paraphrase my submission, not going into it. There are several provisions under the Constitution of India which applies only to particular states, including the state of Assam. So there can be a law applicable only to one state. My lord, page 49, I have, my lord, pointed out the provisions which are applicable only to Assam. This is on, my lord, the classification based on territory.
Yes.
My lord, these are my respectful submissions. Only one thing, my lord, as a last thing, as I, my lord, I have some kind of an apprehension. My lord, I would request the interveners to keep in mind that they are here to protect 6A, meaning thereby they represent people from 51 to 71 and not post 71. So, my lord, their submission may not be such that though we are on the same side, I have to give rejoinder to them. That's all. My lord, I am
confined to the validity of 6A.
only validity of 6A.
Right.
Yes.
Mr. Attorney General, should we hear you right after lunch?
My lord,
Because we're
after
almost at
lunch-
the stroke of lunch.
After lunch, whatever details, my lord, I could get,
Yes.
I would submit before your lordships in 2 minutes, my lord. During lunch hours, we'll do that. And it would also be a part of my affidavit, which I'll file latest by day after tomorrow.
But in the event your lordships don't finish today, what is your lordships planning to do, my lords?
How long would you take, Mr.
Not very long, my lords. I think my
Mr.
learned friend
Attorney
has
General,
covered.
Mr. Attorney General, how long would you take? Because I think this has been covered substantially now. Mr.
I have
Sibal,
a
about the
brief note.
same?
That's fine, my lords. There's no problem.
And Ms.
I will
Jaising,
take very long.
Ms. Jaising, about the same time, I think?
About the same time as Mr.
All right. And then we can ask them to complete the rejoinder today then.
Just take a period of time. I have that one pager that my lords had said.
Fair enough, we can give you a one pager. So once,
Just summarize.
so what we can do is suggest is this. We start at 2 o'clock. We request all of you to, we have Mr. Attorney General, Mr. Sibal, Ms. Jaising. If you can conclude by, say, by 3 o'clock.
Not possible.
Mr. Attorney is saying 15 minutes.
I have a brief
15
note which I'll read.
Yes, say 10 minutes for the attorney, say 10, 15 minutes.
Whatever your lordships.
So what we are saying, if you finish it by 3 o'clock, then we can give them an hour for rejoinder and then conclude the matter thereafter.
Anyway, but
Anyway, we'll see how it goes. We'll see how it goes.
Anything.
May I take your permission, my lord, to file a list of dates, reference to the compilation? It'll
Absolutely.
speed up everything because no one has really filed a list
Is
of
it
dates.
already, I just saw a list of dates in the attorney's written
In
submission.
in
I'm sorry,
my,
Mr. Solicitor
in my
General.
note, there is, but I skipped it because that was argued before it.
Ms. Jessie,
Yeah.
is your list of dates part of what you have filed in the soft form?
Compilation, no, it's reference to the compilation already filed. All the dates
No,
are
I'm asking
available
something
in the
else. Is
compilation.
your list of dates already in the electronic record which is made available to us?
No, my lord, not in the electronic record, it's culled out from the electronic record.
Then why don't you do this, maybe over lunch, just the list of dates, you
Yes.
can email it to the court master, so you
Yes.
can then tag it as a volume, so we, all 5 of us will have it.
We can do that.
Because I have
And with
also
copy
just
to
in
all of us,
response to my learned friend's argument, just made a 5-pager, Maharaj, that can be uploaded.
All right, then Mr. Sibal and Ms. Jaising's brief note, and anybody else who has that one pager, please over lunch, over lunch, give it to the nodal council.
Yeah.
There's a nodal council in this
Yes.
matter. Nodal council will upload it and give it to the court
Well,
master.
if I may be permitted to upload the one pager, not today, but tomorrow, because I have longer than one page, which I would like to edit down to one page. So,
That's a very fair suggestion.
Please.